Good afternoon, everyone, and welcome everyone to today's session. As you are aware, we have discussed about medical negligence in our last session, and we will continue this discussion in this session as well. We will look further into medical negligence and we'll discuss and delve into some further points in this practice area. So, we are fortunate to have Mr. Sushanta Shaha, Principal Solicitor of Avista Solicitors, who has been practicing medical negligence and personal injury claims for a long time. So, welcome, Mr. Shaha, in today's session.
Thank you, Mr. Joydev, for inviting me.
So, if I just go to the main point, I mean, there will be three questions, main topics, but if I go to the first one, so we have discussed last session that patients, it's general ideas about personal injuries. So, in the UK, there are medical records. So, when a patient or when a client who thinks that he might have personal injury claim, medical negligence claim, what legal right he has or she has to access that medical record?
Okay, let me first recap what we have discussed quickly.
Hmm.
A professional, whether it's nurse, doctor, or surgeon or dentist, they owe a duty of care to their patient. And
Hmm.
that duty of care was substandard. As a result, the patient has suffered an injury, and that's why the claim has arisen. Okay.
Hmm.
So every patient in this country, they have right to access that what information the doctor, GP, or the hospital hold about that patient. They can
Hmm.
access to the medical records, they can access to the treatment plan, they can get all the images of the injury or incident, whatever happened. Every single point a patient can have.
All right. So, when they get that medical record, uh, do you think that they will be able to know what they are looking into or what they're
No, no,
expecting from that report?
it's not possible for a layperson to understand, to go through with the bulk of, very big bulk of, GP records, hospital records. So that's
Hmm.
why they should immediately first consult, if they suspect that there is a genuine, clinical negligence claim. So they should immediately seek two advice: independent legal advice, I mean, like a solicitor who has the knowledge in this area of practice. And
Hmm.
you have to remember that nothing is more important than health. Okay. They should immediately look after their health and seek, medical treatment. So these two things we always advise.
All
Sometimes,
right.
what happened, client, what they do, they, rather than, taking the medical treatment, they think if
Hmm.
they go to a solicitor, they will recover the compensation
Hmm.
and they will have the better life. This is not the case. We
Hmm.
always advise to our client that nothing is more important than your health. So take care of your health. First, seek the, appropriate treatment you require. Simultaneously, I'm here to look after your best interest so that you get the right treatment, as well as if there is a claim to be answered, so you recover the compensation you deserve.
Hmm. All right. I will just look into another matter quickly. There is a point about second opinion. I
Mhm.
mean, there are some serious diagnoses, or sometimes the clients are uncertain whether the doctor is right or not. In that circumstance, can they request for a second opinion in their matter?
Of course, even we always encourage to our client
Hmm.
that it is your right. What is their right to know? that what is the treatment plan,
Hmm.
what is the consequence of the treatment, what is the likely risk, what will happen if they don't take the medical advice, what is the likely outcome from that treatment. These are the basic questions for any uh, client. They should be aware of it.
Yes.
And
Yes.
if they have suspect that they are not you know getting the right answers, they can definitely request that I wish to obtain a second opinion before I go for major treatment or major surgery. It is their fundamental right.
All right. I mean, yes, your answer touches my second topic today, which is informed consent, I believe. So, how important is informed consent in medical negligence practice?
These are fundamental. Is
Mhm.
significant impact can happen to any patient's life. If a doctor failed to give sufficient information that what treatment they are doing with this patient and
Mhm.
what are the risks, and fail to take the informed consent from the patient, then it's easy for solicitor, for us, to establish. Because what happens sometimes, however, you need to remember that the doctor has some prerogative right. Like
Mhm.
procedure is taking place, and taken the consent from the patient that bowel will be open and they will do particular surgery. But
Mhm.
having opened the bowel, what was intended to be done by the doctor, they have found something different that which needed to be done as a matter of urgency.
Mhm.
Doctor cannot wake the patient up or cannot leave the theater, go to the next of kin, obtain the consent. They cannot do that.
Yeah.
That's their right, that they are doing for the best interest of the patient.
Okay. So it's all about reasonableness, I would say.
Exactly, as we have discussed in the first episode.
Mhm.
Exactly.
Okay. So yeah. I would like to go back to the documentation question again. So we have seen clients who have not got the documentation, but they come to us for advice and also want to commence the claim. How would you help them in getting that documentation from the hospitals and the doctors?
Okay, sometimes what happen, claimants or the victim, they they don't know whether they have the genuine claim or not. They come to take our services. We always request our client that please give us the brief facts. And these things happened, even if you see maybe 2 years back, their
Mhm.
memory has faded. We always advise our client that take every single notes when your memory is fresh, so that no fact are missing. And what we do, we advise our client that you can individually make a formal complaint to the NHS, any trust or the GP. But if they go through a proper channel, then it's easy for them to get the information, all the GP records, hospital records, ECG, surgery, all the information, all the
Mhm.
images. So it's easy for them.
Is there any financial cost for the client for this?
No, 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 no. There is no cost involved whatsoever. Whatsoever.
All right.
Under
So,
the Data Protection Act, everybody has the right to access to their health record. There is no cost
mhm.
whatsoever.
All right. Got it. So, yes, I believe that's all my question for today. And in our next session, we will be discussing about how to commence proceedings, limitations, and compensation and other areas of negotiation and very important points
But
about damages.
one thing I need to highlight to this, that whoever suffer any kind of negligence from the GP, hospital, or dentist, or from a nurse, they always should seek the independent legal advice and the proper medical treatment.
Hmm.
Sometimes, what I have seen mainly from the Asian community, not from the, uh, other community, mainly the Asian community, they don't know whether due to the, prolonged delay or misdiagnosis, whether there is any claim or not. As you can see, we are dealing at the moment few clients where they have received a letter from the hospital
Hmm.
that they have failed to provide the proper treatment to the patient. That's why they are sending the apology letter.
Hmm.
Until and unless they have received that letter, they are not aware that they have received the treatment which is not up to the reasonable standard of care. They didn't
Hmm.
know. So that's what I'm saying. If they have any kind of suspect that due to delay diagnosis or mistaken diagnosis or wrong treatment or any surgical error, they always should consult a solicitor without any further delay. Delay
Hmm.
defeats the justice, as you know. So
All right.
they should consult with a solicitor who has the knowledge in this area of practice, and they will hammer for them. There will be no cost, end of the day for the victim to get the justice done.
Yes. So if I just summarize the main 2 points we have discussed today is one, seek legal advice if you think that you have got a claim, and
Mhm,
then the the patient or the client also has a duty to limit their damage reasonably.
mhm.
So these are the main points to take today, and we'll be discussing about the proceedings, limitations, compensation, about everything in the next session. And hopefully you will be there as well to discuss about it for our viewers.
No
And
problem.
with this, we are saying goodbye today.
Thank
Uh,
you, Zainab.
all
It's
right then. Have a nice evening.
you too. Bye bye.
Bye.